Good day, class, and welcome to this facilitation class on PUL341, Topic 2. We shall continue from where we stopped last week, where we spoke on some issues, on some topics under Topic 1. I'm Dr. Alera Akujobi, your facilitator for this class. So what do we have on the Topic 2? Basically, on the Topic 2, we shall be looking at classification of offenses and why the classification of offenses. We shall also be looking at a brief history of the Nigerian criminal law prior to 1914 and after that, and even after 1960. We shall be looking at what the justice system was like briefly. Then we shall go into criminal responsibility in Nigeria. When we talk of criminal responsibility now, what are we talking about? What makes the accused person liable? What makes him criminally liable? What are those things that must be established before you can say one is criminally liable for an offense or a crime? So these are what we shall be looking into under Topic 2. And by the time we finish, we'll be able to understand and differentiate both the act, the intention, and also the physical act that must be established for an accused person to be deemed liable or guilty. And of course, we shall be looking at the statutory provisions under the various laws, under our penal codes, under the Constitution that makes an accused person criminally responsible. I'm Dr. Alera Akujobi, your facilitator for this class. Please, thank you for joining. Welcome, students, to another day on PUL 341, Criminal Law 1. Today we shall continue from where we stopped last week, and we shall be looking at similarities between the Penal Code and the Criminal Code. Don't forget that we spoke last week on what we meant by criminal law, the different definitions of criminal law, and all of that. Now we shall be looking at the two codes. Are there similarities between the two codes? Definitely there are. The two codes actually codify the common law of crime. This is deducible from their origin as well as their content. So we see that save for a few portions or a few provisions in the Penal Code, which incorporates the Islamic law, such as where we have things like drunkenness, incest, fornication, adultery, and all the others, there's hardly any difference. We also observe that each of them entrenches an accusatorial system in which summary trials are held at the magistrate court and on information at the high courts. So we find that these are some of the differences that are basically contained in the two codes. Of course, we know that if we're looking at, those are some of the similarities. If we are looking at differences, we know that why one, for instance, contains some aspect of Islamic law, where we have issues like adultery and all of that, the other does not contain such. And of course, why one is functional in the north, the other one is functional in the south. Last week also, briefly, we looked at the objective of criminal law, where we said there was the need to preserve the moral fabric of the society, and in this context, we look at the offenses like indecent assault, rape, and the like. Then the next was that also the need to protect human dignity and human harm. So offenses that comes under this are offenses like assault, criminal defamation of character, and the like. And of course, we also have the need to protect valuable property of individuals, the need to protect the interest of the owner in such properties, and covers offenses like arson, stealing, armed robbery, false pretenses, and also others. Of course, we also see that one of the objectives also of criminal law is the need to preserve the state from disintegration. For instance, for such offenses like sedition, offenses like treason, official corruption, and things like that, this will definitely help us in ensuring that the law, the criminal law, is intact and protects not just the individual, but also the society, the government at large. Now, we shall be looking at types of how to differentiate crimes. For instance, talking about how to differentiate crime, we know that there are various types of crimes where we have felonies, we have misdemeanors, and we also have simple offenses. Now, in trying to differentiate them, what we want to look into is the degree of punishment that is available for each of them. If it's a felonious offense, if it's a misdemeanor, if it's a simple offense, what are those punishments that are being prescribed for them. We also have to look at it, whether is it a bailable offense, is it not bailable offense. For instance, we know that if it's a capital offense where death has been caused, most times it's not bailable. But other than that, going by our statutes, most other offenses are bailable offenses. So we have to look at the kind of offense or the kind of crime that it is. Then we also have the issue of proceedings. What kind of proceedings are being carried out in each of them? Under civil proceedings, how is it being conducted? The conduct of criminal proceeding is different from that of a civil proceeding. So these are ways you can differentiate the kind of crimes they are. Whether are we talking of an offense here that's against the state, or are we talking of a wrong here that's against the individual and also consists of different types of punishment? Because while one is tending towards compensation and restitution, the other one tends towards damages and the likes. So these are some of the things that we'll be seeing when talking about differentiation of crimes from other types of wrongs. Again, like we've looked at the differences, we shall now be looking at a brief history of the criminal law. Talking about brief history, what we shall be talking about is we shall be looking at the period before the advent of the British colonialism. So we'll find out that before that time, definitely we had in existence our own kind of system, our own kind of criminal laws, which were in varying forms in the different communities that make up the present day Nigeria. In the South, for instance, we had various criminal law systems that were based on certain social norms, which prescribed punishments through imprisonment as a form of, though imprisonment was not known as a form of punishment in some areas. But then we had all kinds of punishment, banishment, even death at times, were prescribed in those days, depending again on the type of crime. This was all before the advent of the British. In the South, we had various laws, like I said, that were based on our social norms, which also prescribed the punishment. A more elaborate Muslim criminal law system existed in the North, powered by the Maliki school, that was made up of highly developed school of jurists. Now, the English common law of crime was first introduced in Lagos colony in the year 1963, while customary criminal law applied outside of Lagos. In 1904, what we had was the criminal code that was introduced in the northern Nigeria, was introduced in northern Nigeria. And following the amalgamation of 1914, the criminal code was extended to the whole country in 1916. Now, the application of criminal code in the north was limited due to the wide jurisdiction given to the Sharia court. Thus, we had two sets of criminal laws in operation in the north, which resulted in serious conflict. So while we have the Islamic laws, we also have the criminal law that was introduced by the English common law of crime. And of course, we know that there was bound to be conflict, because while one was mainly based on religion, the other wasn't. So this led to a kind of conflict in the region, because what we had a system whereby you had various courts, and this court, because of the introduction of the English system, most of the even customary laws had to still pass through the English system. So making many of these laws that were originally in place repugnant to natural justice, equity, and good conscience. And of course, this didn't augur well with many of the this it didn't augur well with the system, particularly in the north. However, by 1959, the penal code specifically designed for the north was introduced to replace the criminal code. In 1958, customary criminal law was abolished. Thus, Section 22, subsection 10 of the 1963 Constitution, now Section 36 of the 1999 Constitution, provides that nobody shall be convicted of a criminal offense unless that offense be defined and the punishment therefore is prescribed in a written law. So between 1959 and 1963, this was the position. So both the criminal code and the penal code covers not only offenses committed within the territory to which they apply, covered, both the criminal code and the penal code covered only offenses committed within the territory to which they apply. Like I said before, difficulties may arise where an offense comprises serious elements, some but not all of which are occur outside the jurisdiction. The problem was dealt with Section 12 of the Criminal Code as well as Section 4 of the Penal Code, where the initial act of commission of such an offense, where it occurs within the territory covered by a code, another element occurs outside. What happens? Then, we'll find out that where the subsequent element has occurred, then the committer is liable as if all the subsequent elements had occurred within that territory. Then, of course, we had where the initial act of or omission of the offense occurred outside the territory, outside the territory, but others within the territory, the offender would be liable to as if the initial act had occurred within the territory. We had cases like Patrick Joven and the state to throw more light on this. So, for this purpose, any mode of entry is sufficient. It is immaterial whether the entry into the state by the accused is voluntary or not. Of course, see the case again of Patrick Joven and the state. So basically, what we have was that after 1960, we now have two sets of codes on operation in the country. We have the penal code operative in the north, and we also have the criminal code operative in the south. These are the main penal codes that are in existence today. So these codes, of course, they've been existing within the years, and of course, there's time. Many of them need amendment as we speak, because many of the offenses either they are obsolete or the punishment for them do not meet the reality of the time. So to that extent, there is need for a lot of amendment to some of these codes. So having said that, of innocence. So when talking about presumption of innocence, So like we've also said, the intention behind it is not to shield the guilty, but to prevent the conviction of the innocent person. The presumption remains with the accused throughout the trial until it's overcome by the prosecution. I hope you understand this, that the presumption of innocence remains with the accused person. No matter how visible the facts are, is still presumed innocent until the end of the trial, where the prosecution is able to establish that the accused person is guilty. So the case of Tajuddin Alabi and the state, as seen on the slide, we also throws more light on it, where the Supreme Court held that the prosecution is required to establish the essential element of an offense. He must produce all the vital witnesses to testify during the proceedings before a trial court comes to conclusion that an accused person has committed an offense. So we can see the elaborate burden on the prosecution. His duty is not just to do all the proper investigation, do everything possible in order to establish his case. Because where the essential element of any offense is not being established, of course, it is not deemed, the prosecutor will not be deemed to have proved his case. And of course, it is not proved beyond every outer of doubt that we are looking at, because that would be kind of reasonably impossible. But proved beyond every reasonable doubt. I hope we are getting it. That it is not proved beyond every outer of doubt that the court is after, but proved beyond every reasonable doubt. There's a difference between those type of proofs, because you can hardly prove everything possible, but at least to the common man, to everybody listening, you should be able to establish that to a great extent, you'll be able to prove that the accused person was guilty of that particular offense, and that behind every reasonable doubt, everybody listening now, hearing the matter, say, yes, this is sufficient, this is adequate proof by the prosecution. Other cases you can look at is the case of Nasiru and the state, and also the case of William and the state that will throw more light on this. I have a question for us here. Uh, on this question, I want us to, for instance, I said the presumption of innocence is viewed as shutting out justice instead of doing justice. Do you agree? Or I said discuss. The presumption of innocence is presumed as shutting out justice instead of doing justice. Do you agree? So I want you to look at it very well. And if you agree, I want you to discuss it, to look at it very well. If you agree during the class, of course, we are going to discuss it. Do you agree to this? Where you disagree, let us know. Where you agree, you also give your reasons why you agree. Of course, when giving reason, don't always forget, as a law student, you must always back it up with judicial authorities. So we shall continue from there now, and of course go to criminal responsibilities or criminal responsibility. So in criminal law, when we're talking of criminal responsibility, what are those things that we have in mind? Now, um, we've just said now that every accused person is presumed innocent until the contrary is proved. Every accused person is presumed innocent until the contrary is proved. So now, under criminal responsibility, the fundamental rule of criminal responsibility that a person cannot be guilty of an offense which does not exist. A person cannot be guilty of an offense which does not exist. A person cannot be found wanting of an offense that does not exist. In other words, such offense, like we said before, if you remember when we were talking about the characteristics of crime, the characteristics of an offense is that that offense must be in a written law. So if the offense does not exist, there's no how you can punish such a person. If you remember, we saw this in our section 36, subsection 12 of the of the Constitution. So criminal law cannot control our beliefs. I hope we understand, but it can control our acts and our omissions. What do I mean by this? Criminal law will go all out to control your act because whatever you think of and you manifest it, as long as it's affecting you another person, as long as it's affecting the society, of course, that is where criminal law will come in. For instance, if a man breaks the law, it will not be judged by the subjective standard of his beliefs, but the objective standards of the law. He will not be condemned by the subjective standard of his, but of course by the objective standards of the law. So this is very, very important. We have to take note of that. That criminal law is after our acts and our mission. What you are thinking or what you meditate on is not really the interest of criminal law, because until you bring out until you manifest your thoughts, your intentions, that is where criminal law comes in. That is where the law comes to say, no, you cannot do this. No, you can do this. No, you can act like. No, you cannot act like. And that is the point that is important. Also important for this section is that you need to know is section 24 of the Criminal Code and section 48 of the Penal Code. These sections talk about the basis of criminal responsibility that finds expression in the maxim of actus non facis nisi mens sit rea. This means that the intent and the act of the accused person must occur to constitute the crime. Are we following? The intent and the act of the accused person must occur to constitute the crime. As we look into this, we will also find out that it is possible, for instance, for the intent to come later on, okay, during the act. These are all possible. We're going to look at those instances later on where all of these are possible. So a person is presumed to intend the natural and probable consequence of his acts. For instance, a man that inflicts machete cuts on another person cannot be said that he had no intention to kill or at least to cause grievous bodily harm. I'm sure you agree with me. For you to have constituted such damage, you must have intended to know or to foresee that your action will cause some grievous bodily damage to the person from whom you are doing such a thing to. Interesting case there to look at is Mohammed and the state, which the citation is also given there for us to look at. So we are going to be looking now at we'll be talking about that a person must have an act and a guilty mind in order to be criminally responsible. So now, what are those elements of criminal responsibility? We are going to look at those elements briefly of criminal responsibility. Um, Now, to establish the guilt of an accused person in a criminal trial, the prosecution must prove the occurrence of the physical act and the guilty mind. So, the margin, like I've said before, is that a person cannot be guilty, cannot be convicted and punished, except unless it can be proved that he was guilty of an act with guilty knowledge. This physical act is known in Latin as the actus reus, while the guilty mind is normally seen as the mens rea, are the elements of crime. And like I said before, they must coincide in point of law and point of time. Now, physical acts. When we're talking of physical acts, we are talking about those acts that relates to those issues that relate to acts, omission, passivity, and the nonchalance of the accused person at times can also result in physical acts. Examples could be like poisoning, shooting a gun, fighting, stabbing someone. All of these are physical acts that one or any one of us can be found doing. We also have like omissions. Omissions too can constitute acts. For instance, where the law expects you to do something, where the law imposes a legal duty on you, a moral duty on you, a positive duty on you, a common law duty on you to act, and you refuse to act when you're supposed to act. All of this can constitute the physical act or the actus reus of an offense. And we've seen that, like I put some sections there for us to look at. Section 199, Section 20, 347 to 348, and all of that. Just note that in most offenses, for it to have been an offense, it's because there was that physical act or there was that omission on your part, and refusal to have done what you are supposed to do constitutes the physical act. That's what makes it a crime, particularly where, like we said before, where there was an intention, where there was a thought of it, where there was a foreknowledge, where there was uh, a foreknowledge, where there was that negligence on your part to do something. Of course, you would have been deemed to have constituted a crime. So, in continuing on our elements of crime, we shall also be seeing that cases for omission, like I've put the case of R and Miller there. Of course, go to your course materials and look at some of these cases, or go to your law books. You'll see some of these cases there. If you remember at the beginning, I think I made mention of some of the books we can be reading. Our course materials, criminal law textbooks in Nigeria. You have that of Okonkwo and Nash that you can always make reference to. Your constitution must also be your guide at every given time. Your penal code should be by your table at every given time, so that when you have a reason to go to some of these, uh, resources, you can make use of them and feed and get answers to what you need. So it is also possible that one can be present at the scene of a crime, and failure to act will not constitute any liability on such a person. That was the case we saw in R and Akani, where an old woman died in a house which had been engulfed by fire. Held that the person that stood there and did nothing, though his behavior was disgraceful, his act was not criminal. So we have to be able to understand some of these things. Like, how come is it possible that one can be there? So why is the criminal law not imposing liability on such a person that refused to act? Well, that is the criminal law for you, because the person, there was no legal duty on that person to act, and there's no law so prescribed that his failure to act will render him liable. So to such an extent, such a person is not criminally liable for his act or omission. In some instances too, words are enough to constitute the act, like the case of R and Nwaoke, where the accused person pointed a juju or a substance at the deceased for refusal to pay him his money, and said, "Since you refuse to pay me my money, this juju will kill you, or since you refuse to pay me, you shall no more eat or drink. He left the substance and the disease down, and the disease became distressed and died, committed suicide and died. Will you say that it was because he said those words that the juju person, that the diseased person died? Of course, the court held that suicide was not reasonably foreseeable as a consequence of the threat. I hope you are appreciating this because there are a lot of things that the court looks into in coming to its conclusion. Okay, by telling somebody go and hang yourself, go and steal, or go whatever, is that enough? And then the next morning you find out that yes, the person truly went to hang himself and he was killed and all of that. Even though at times in some instances, depending on our environment, depending on where one comes from, some of these things we tend to constitute a crime in the circumstance. But the court held that suicide was not reasonably foreseeable as a consequence of such crime in that instance. So these are some of the things we see. They're now talking about guilty mind. When we talk about guilty mind, that's the mens rea. What are we looking at? We are saying that it must be proof that the accused person committed the acts, in a particular state of mind. These are inferred from the following: the intention, what was the intention he was having? Was he reckless in the process? Did he have knowledge? Did he have foresight? Again, very relevant sections to when we are talking about guilty mind is section 24 of the Criminal Code and section 48 of the Criminal Code. These sections are very, very, very relevant. And it's important that you read them, you understand them, so that you're able to apply them when the need arises. So, under intention here, we have seen that it is a case where a man does an act deliberately, knowing that it is highly probable that grievous bodily harm will result. That will say that the man or the person would have been deemed to have intention, like the case we had earlier, where somebody hits or stabs somebody with a machete. Of course, there was an intention to cause grievous bodily harm that could have been inferred from the act of the person. Again, I have the case there of harm and DPP, where I said we should go back and read. So, the case we looked at intention, briefly also on negligence. Negligence is a negative factor or state of mind which is capable of crossing out available defense of accident. Again, section 24 of the Criminal Code is also on that particular aspect. So, ordinarily, it is a common base for true liability. However, in criminal law, more than ordinary negligence is expected. For instance, under the law of tort, you have your neighbor's principle and all of that, Donegal and Stevenson. This one we need more than just ordinary. What is needed here is gross negligence. It must be proved that you were grossly negligent in your act, in doing what you ought to have done. Here we can see that we have the case of Edu and COP. I also put there the case of Moses and the state, where it was held that carelessness on the part of the driver, no matter how slight, amount to dangerous driving, and this is regarded as negligence. So that is for negligence. So all you need to understand is that what is needed is something that is more than that is needed in civil cases. That is something more serious, something more gross, in criminal matters. Then, of course, we look at knowledge. In most cases, the statute prescribing the offense may use the word knowingly, willfully, or fraudulently to denote the requirement that the prosecution must prove knowledge as an essential ingredient of the offense. In some cases, the statute may not expressly state knowledge, but of course, the court imputes knowledge. For instance, obstructing a policeman in the performance of his duty. It's a policeman. He's wearing his uniform. So that is enough knowledge for you to know that whatever you do to avert him from conducting his job, from doing whatever he ought to do, it will be presumed that you had knowledge that he was such, and of course you will be deemed to have obstructed him in the performance of his duty. So this is all about. Then we of course have recklessness. We of course also have foresight, like I've mentioned before. When we are talking about those things that are regarded as the mens rea, the guilty mind that is needed in the commission of a crime. So Quickly, we shall be looking at application of physical acts and the guilty mind in Nigeria. Under the criminal code, we will realize that the word actus reus and mens rea are not used, but they are purported and they are used in practice because of their meaning. So you will not open your criminal code now and say the word actus reus or mens rea. No, you talk about the physical act and the guilty mind. So, but they are purported. So, in the case of Ibikule and the state, the court laid the following foundation that, with the exception of the defense of insanity and subject to certain statutory exceptions, the onus of establishing beyond reasonable doubt that the accused not only committed the act, but that he did it with the necessary mens rea rests on the prosecution and never shifts to the defense. So this is what we have explained in the past, if you remember. So it is always on the prosecution, except of course in the defenses of insanity and of course in that of intoxication and others. So what we are saying here is that the prosecution has all the duty to establish this. In Abike and the state, Nikki Toby remarked on the concept of mens rea and actus reus and the way they relate. He said, and I quote, I entirely agree with the appellants that to convict on the above subsection, the prosecution must prove that the accused had mens rea and actus reus. Put in simple parlance, mens rea means guilty mind, and actus reus, that's an actus reus guilty act. The period of time between the two cannot be determined in vacuum, but in relation to the factual situation in each case dictated by the state of criminality of the accused at the material time. I hope we're following. There are instances where the mens rea is automatically followed by the actus reus. The above case of proximity apart, there could be instances of spontaneity. So what we're saying here is that he has again reiterated the fact that even though these concepts are not found in our many of our texts, but they are imported concepts that are purported in our acts, and their meanings have been so explained. So they could be there at the beginning of the crime, or they could come in later. The guilty mind could come in later, depending on the circumstance of each case. I hope we understand. So take note of those cases, Ibikule and the state, and also the case of Abike and the state, and take note of the reasoning or of the remarks of the courts, so that you are able to understand it very, very well. So from what we've said, other cases you can also still note are the case of Tabo Meli and R, where, for instance, both acts must constitute, both the physical act and the the guilty mind must constitute a crime at the same time. It is also possible where, for instance, where there's more than one cause of harm. Maybe, for instance, somebody is being hit down or there's been a fight and one injured the other, and you are trying to rush the person to the hospital. In the process, you are involved in an accident and the person dies as a result of head-on injury. Of course, you can see that it is not the death of that person is not arising from the fight of the accused person. There has been a case of novus actus intervenus. That is a new intervening act that has changed the whole train of the whole results. So it is, we should be able to understand where we can say that yes, there are more than one cause of harm. Yes, there was a fight. The fight led to some injury, but it wasn't what led to the death of the accused person. This was what led to the accused person. So is the accused person guilty for as a result of the death of the for the death of the disease? Those are what we should now be determined that such cases. So you can always raise the argument of novus actus intervenus. Now we have some exceptions, for instance, under the case of Fagan, a Metropolitan Police Commissioner, where the accused was reversing his car on a road and the police constable directed him to drive the car forward and park at a precise point. The accused drove the car with the wheel on the constable's feet and even abused the constable, after repeated demand by the constable that he remove his car from his feet. Now you can see that even though at the initial stage there was no guilty mind, but with time, as at that point where he was told to remove his car, and instead of removing his car, he started insult. So at that point you can link it up that there was an intention to commit a crime. And also, you can also see the case of Attorney General and Northern Ireland and Gallagher, where Lord Denning noted that if a man, while sane and sober, forms an intention to kill and makes preparation for it, knowing it is wrong thing to do, and gets himself drunk so as to give himself courage to do the killing, and whilst drunk, carries out his intention, he cannot rely on self-induced drunkenness as a defense. The wickedness of his mind before he got drunk is enough to condemn him, coupled with the act which he intended to do. So these are all, exception to those general rules where we've been talking about. So where, for instance, one needs Dutch courage to do an act, and you do all you can do to get that Dutch courage, you can no longer say that you were drunk, that this was not your mind or this was your mind. The facts of the case speaks for itself. So finally, I will leave you with a question. That is, the question is to determine the physical act and the guilty act of assault, giving examples with authorities. To determine the physical act and the guilty act of assault, giving examples with authority. I want to believe this would be very easy for you to do, because once you know what an assault is all about, you haven't spoken about what physical act is all about, what guilty mind is all about. Give example of about 2 or 3 types of assault. For instance, state what their physical acts are, state what the guilty acts are, look for authorities to support. When we're talking of authorities here, we're talking about both judicial authorities or statutory authorities. So if you're not able to get cases, that judicial authority, look for statutes. What provision of the criminal code, what section of the constitution, what provision of the penal code can help you to give more flesh to your answers. Like I've always said, in law classes, students do not give answers without stating authorities. You do not give your answers in vacuum, in empty answers. You must back it up with legal authorities. I hope you'll be part of this class. So I hope to see you next week. And when we meet next week, we're going to answer our questions that we've given, that the questions that have been given us before we proceed to the next class. Thank you for your time.